This is a PowerPoint presentation for East Texas Baptist University Criminal Justice 1311 Fundamentals of Criminal Law, and I'm Eric Hillman. This is designed for in-class presentation but has been modified for online presentation due to the coronavirus issues affecting our country and ultimately our campus. This presentation is based on the textbook Criminal Law, the 12th edition by Joel Samaha. This is a textbook that you should have purchased for this class. And this is Chapter 4, Mens Rea, Concurrence, Ignorance, and Mistake. You see, it actually says Chapter 4A. In order to reduce the size of the files, I've divided each chapter into smaller sections. So we'll have to post separately Chapter 4A, 4B, 4C, 4D, etc. We're talking about Chapter 4 in the textbook. The learning objectives you do not have to memorize. They're basically a blueprint for where we're going in this chapter. We're going to define mens rea, distinguish between intent and motive, understand the 4 criminal mental states, specifically in the state of Texas, understand what strict liability means, understand the concept of concurrence, understand what causation means as it's related to a bad result crime and what is a bad result crime. We're going to differentiate in this chapter between factual cause and legal cause. We're going to understand by the time we're done with the chapter what ignorance of the law means and whether it's a defense, and to understand what the concept of ignorance of facts means, whether it's a defense, and how ignorance of facts differs from ignorance. So when we talk about the words mens rea, this is actually a Latin term that means evil state of mind or guilty mind. As you recall from Chapter 3, all crimes require an actus reus, or a guilty act. Most, but not all, crimes require a mens rea. The reason is, in criminal law, we only want to punish those people who are blameworthy. It's right to punish people we can blame. The question then is it right, at least sometimes, to punish people even if we can't say that they did anything wrong? And we'll talk more about this when we talk about strict liability. And there's an interesting quote from Justice Holmes. He was formerly on the Supreme Court, the United States Supreme Court, and he says, even a dog distinguishes between being stumbled over and being kicked. And I've had the experience when I've accidentally tripped on my dog or accidentally stepped on his toe or something, and he'll whine, and then he'll immediately look me in the eyes, and he looks at my facial expressions and my behavior because he wants to know if I did it intentionally or not. And if I'm still responding in anger at him, he knows I did it intentionally, and he'll try to go hide. But if I adopt a very soft tone of voice and tell him I'm sorry and pet him and stuff, then he immediately forgives me. He knows it was an accident. He wags his tail and we're friends again. The same concept with mens rea. We need to know if a person intended to do something or knew that they would do it, or they were reckless or they were negligent. All these concepts we're going to talk more about in this chapter. Well, we said we were going to distinguish between intent and motive. So let's talk about motive. What does that mean? A motive for a crime is the reason that you commit a crime. Motives often have to do with hating someone or loving someone. Basically, emotions can get out of control. As a general rule, it's not necessary to prove motive. We don't have to prove if you killed someone. We don't have to prove if your motive was because you hated them, because you loved them and your love wasn't returned. because your motive was greed. You don't have to prove that perhaps I was written in the will of this person. I knew if I killed him I would inherit some money. Motive, as a general rule, does not have to be proved. If I kill a student in the classroom and all the other students are witnesses, the assistant district attorney will charge me with murder, and the assistant district attorney will call the other students as witnesses to testify before the jury. And several students will testify, yes, they saw Dr. Hillman pull a gun and shoot a student in the classroom. And that will be enough to convict me of murder. They don't have to prove why I killed the student. They don't have to prove that it was because the student embarrassed me by asking me a question I didn't know, or the student said something bad about me on Facebook. Those are motives as to why I killed the student, but they don't have to be proved. All the DA has to prove is I did in fact kill them, the actus reus. Now, they're going to have to prove some form of mens rea, intent or knowledge, to charge me with murder, recklessness to charge me with manslaughter, or negligence to charge me with criminally negligent homicide. But the DA does not have to prove motive, that is why, the reason I killed that person. There is one exception, however, and that would be for hate crimes. If I kill a student because I don't like black people, so I kill a black student. I don't like Hispanic people, so I kill a student of Mexican origin. And they want to charge me with a hate crime. Now, generally speaking, hate crimes have higher levels of punishment assigned to them. So if I'm charged with a hate crime, then the district attorney does have to prove my motive for the crime. Although motives are not required to be proved, they can be used to prove intent, and they can be considered in sentencing. And so if the district attorney subpoenas my Facebook page, and on my Facebook page I said, I'm going to kill a student today because this student embarrassed me yesterday in class. Well, that's my motive, because the student embarrassed me. But the DA doesn't have to prove it. However, when he charges me with murder and I say, well, I didn't intend to kill the student, I just pulled my gun out to show him. I got a brand new gun and I was showing him my gun and it accidentally went off. Well, the DA doesn't have to prove the motive being why I killed him, doesn't have to prove that I killed them because they embarrassed me yesterday, but they do have to prove that I intentionally or knowingly killed them. And so when I say it was an accident, I'm saying it wasn't murder. It may be criminally negligent homicide, but not murder. And so then the DA can bring my Facebook page, where I put on Facebook this morning, I'm going to kill a student today because they embarrassed me yesterday. Then the DA can use that against me. That is a motive. Even though he's not required to prove motive, the district attorney will attempt to prove motive to show intent. Because when I go to court and I take the stand and say it was an accident, I was showing him my gun and it accidentally went off, then the DA is put in a position where he has to prove intent, not motive, but intent, that I did it intentionally. And so he will use my Facebook posting of my motive to prove intent. And when it comes to sentencing, if I have an evil motive, that sometimes will allow the jury to give me a longer sentence. Can motive be a defense? And actually, yes, it can. We know that escaping from prison is illegal. So if I escape from prison, I can be charged with escape. Does it matter why? Does my motive matter as to why I escaped from prison? What if I say I escaped because they had bad food there? Probably that is not a good defense. My motive is the food is awful. Nope, that won't be a good defense. What if my mother's on her deathbed? My mother's dying, so I escaped from prison so I could run home and talk to my mother. Well, I can ask the prison to release me with an armed guard to go to my mother's house or my mother's hospital bed. Some Some states, they may do it. Some states, they don't. Most prisons will not release you just because your mother is sick. But as the picture shows here, this is a prison on fire, and there's a prisoner on fire. What if the prison catches on fire? And my motive is to not be burned to death. Is that a good motive? And Texas recognizes a defense of necessity, where if it's absolutely necessary to do a crime, it would be recognized as a defense. In this case, if the prison's burning down and I escape from the prison in order to keep from being burned alive, that would be considered a necessity defense and probably would be valid. And Texas law allows for that, as long as after I escape from the prison, I turn myself in again at the soonest possible time. So in that case, motive can be a defense. When we talk about fault, there's a difference between subjective fault and objective fault. Whenever you see the word subjective, you should always think to yourself, what did I think? Subjective means what did I think, or what do I think? Objective fault means what would a reasonable person think. So subjective fault requires that I have a bad mind. I actually know that what I did was wrong. And the best way to distinguish between subjective fault and objective fault is to give some examples of different ways that laws can be worded. So, we're going to go through several examples of laws and how just minor changes in the words of the laws could change the amount of fault, subjective versus objective fault. So let's assume the law says it is a crime to buy something you know is stolen. This is subjective fault. Remember, subjective fault requires that I actually know that I did something wrong. Here, it is a crime to buy something you know is stolen. So let's give an example. You buy an iPod from some guy on the corner. He says, hey, I got a stolen iPod. Want to buy it? Sure. I'll give you $10 for it. You buy the iPod. Well, you're guilty because this law requires subjective fault. It requires that you know that you were wrong. Here, since he told you it was stolen, you knew it was wrong. So under this wording of the law, you're clearly guilty. And I think that's pretty simple. But let's change the wording of the law to see how it can vary. Objective fault doesn't require absolutely that you have a bad mind. You don't know for sure you're wrong. But what if the law says it is a crime to buy something you have reason to believe might be stolen? You have reason to believe might be stolen. Okay, so now you're on the same street corner and there's a brand new iPod. The guy's telling you, hell, I'll sell you a brand new iPod for $10. Hey, that's a good deal. What's your name? I don't want to give my name. Okay, let me write you a check. No, I need cash. Is it stolen? No, it's not stolen. Well, objective fault. Remember, whenever we see the word objective, we say, what would a reasonable person think? What would a reasonable person do or believe? Would a reasonable person think that they could buy a brand new iPod on the street corner for $10 from some guy who won't even give you his name and insists on cash? A reasonable person would not believe that that's legally possible. So here the law says it's a crime to buy something you have reason to believe it's stolen. That's objective fault. So let's step back. Subjectively, do you absolutely know for sure it's stolen? No, you don't, because you paid money for it and he said it wasn't stolen. So subjectively, you don't know for sure it's stolen. But objectively, what would a reasonable person believe? Do you think under these circumstances a reasonable person would believe that iPod is stolen? Of course. And so this wording of the law, you have reason to believe it might be stolen, is fulfilled. And it requires objective fault, meaning a reasonable person would believe it was stolen. So even if you don't know for sure that it's stolen, you'll still be guilty under the objective fault standard. Because of that, you are guilty. Objectively, you should have known it was stolen. All right, then let's talk about strict liability. There's 4 types of mens rea, all require some kind of fault. But on the bottom of that list, there's actually a 5th category called strict liability, 5th category, and it requires no fault at all. So, what if the law says it is illegal to receive stolen property? It doesn't say anything about you knew it, or it doesn't say anything that you had reason to believe. It just said it's illegal to receive stolen property. You buy a used iPod, so look at this picture and you can see this thing is well worn, it's used, it's probably not worth $200, maybe it's worth $50, I don't know. It's very worn out. You buy it from someone you know and trust, and you decide to give them $200 for it. So you pay a reasonable price for it, probably paid too much for it, and you don't believe it's stolen, but the law says it's illegal to receive stolen property. It is stolen. Your friend didn't tell you that it was stolen, but it is. Under this wording of the law, assuming it's a strict liability law, it's illegal to receive stolen property. Is it stolen? Yes. Did you receive it? Yes. You're guilty. So strict liability requires no fault at all. Here, you were told it wasn't stolen. You paid more than it's worth. You had every reason to believe it wasn't stolen, but because it was stolen, you are guilty under strict liability. Why? Because strict liability requires no fault at all. How do you prove mens rea? How do you prove that someone intentionally or knowingly did something? You can't see it. You can't see inside someone's mind. You can't know what people are thinking. Well, what if someone confesses? The police call me into the interrogation room, and they say, we've got several people who saw you kill the student. And I say, yes, I'm guilty. I killed the student. That's a confession. And that's a direct evidence of my state of mind. Yes, I intentionally killed him because that student embarrassed me yesterday in class. So I came to class today with a gun, and I pulled a gun, and I pointed at them, and I pulled the trigger and shot and killed them. I intended to do it. That is a confession, but confessions are very rare. People know enough in most cases to say, I don't want to talk to the police, I want to talk to my lawyer first. And when they do talk to their lawyer, the lawyer says, you have a right to remain silent, use that right, do not talk to the police. And so yes, there is direct evidence of state of mind, or mens rea, and that's called a confession, but that doesn't usually happen. So instead, the police and the prosecutor have to prove my state of mind by indirect or circumstantial evidence. What would be the indirect evidence? Well, the witnesses. The witnesses say that Eric Hillman pulled a gun and pointed it at the student, pulled the trigger, and the student's dead. Well, that's my actus reus. What about the mens rea? How do they prove I intentionally did it? Because my defense is it was an accident. I can't say I didn't do it because all these witnesses there say I did. So instead of saying I didn't do it, I have to say I didn't mean to do it. Now we're talking about mens rea. I didn't intentionally or knowingly did it. It was an accident. Well, then the district attorney will ask the students who witnessed the crime, you saw Professor Hillman shoot the other student. What else did you see? I saw an angry look on his face. Or when he pointed the gun at the student, he said, I hate you. Or this will teach you not to make fun of me in class. And that would be some indirect or circumstantial evidence of my state of mind. And the jury hearing that would probably say, yeah, Dr. Hillman intentionally or knowingly killed the student, rather than Dr. Hillman accidentally killed the student. And since we can't see inside people's minds, we rely on what they do to tell us what they intend. And so a lot of it is interpretation of facial expressions or verbiage, and that's part of what juries have to do. In a murder trial, there's going to be 12 jurors, and they have to decide, first of all, did I kill him, the actus reus? Secondly, did I intend to kill him, the mens rea, or was it an accident? Now, Even if it was an accident, I could still be charged with manslaughter or criminally negligent homicide, but with criminally negligent homicide, I'm looking at 2 to 10 years instead of 5 to 99. So that's why I'm trying to say it was an accident. Also, if the jury believes it was an accident, the jury could give me probation, and which is much more likely if they believe it's an accident than if they believe it's intentional. That's why I want the jury to believe it was an accident. So they have to decide, did I intend to do it or was it accidental? I've already given up the argument that I didn't do it at all. I don't argue that because I've got so many witnesses saying I did do it. Mens rea in the common law, and you recall from chapter 1 we talked about the common law that was developed by judges over the centuries, long periods of time. Eventually the common law was replaced in Texas and most states by some form of the model penal code. But before the model penal code, they had all these different words that were used. Now, I won't test you on each one of these words, but it's good to understand just how confusing the law could be. Intentionally, willfully, purposely, designedly, knowingly, deliberately, maliciously, premeditation, recklessly, negligently, culpably, gross negligence, without due caution, wickedly, unlawfully, wrongfully, calculated, planned, meant, pre-planned, evil mind, depraved, diabolic, abandoned heart. Well, these are all different terms that different judges and different courts had used. So how do we tell the difference between pre-planned and evil mind and depraved and diabolic heart and abandoned heart? How do we define those and how can we tell the difference? This is all very confusing. In the 1960s in the United States, the model penal code was developed as a guide for states to develop their own penal codes. Most states have some form of or some version of the model penal code, including Texas. Texas doesn't adopt the model penal code exactly, but most of the Texas penal code follows the ideas in the model penal code. So again, the model penal code was a guide. It's not, the model penal code isn't an official penal code. It's a guide created for the states to follow. And Texas follows the ideas in the model. Common law definitions are more complicated, and there are still some states in the United States that follow common law. Key to understanding the common law is distinguishing between general intent and specific intent. General intent means you intended to commit the criminal act, and specific intent means you intended to commit the criminal act and you intended to cause the result. So intending to commit the act and intending to cause the result are two different things under the common law, general intent and specific intent. Interestingly, as easy as these seem to be distinguished on this slide, if you look at cases in even some states in the United States that still follow the common law and still use general intent and specific intent, you'll find even judges who have law degrees trying to distinguish between general and specific intent, and even sometimes they misread or are mistaken in their interpretations. And often judges' interpretations of general and specific intent are overturned in appeals courts. And so the concept is a little difficult. At this point, since we are at Texas College and we are studying mostly Texas law, and those of you who go on in criminal justice, probably 95% of you here, will end up practicing or being a police officer, sheriff's deputy, constable, DPS trooper, game warden, etc. in Texas. We're going to concentrate for the rest of this chapter on mens rea as it applies to the Texas Penal Code. If you go to another state that uses the common law, then I would encourage you to read up more on general intent and specific intent. In the textbook that we use in this class, there's a much more thorough discussion of these common law mens rea concepts. But again, for purposes of our class, we're going to skip directly to the Texas Penal Code. So what are these these levels of mens rea in the Texas Penal Code. There are 4 levels, not including strict liability. Remember, we said strict liability was a 5th level on the very bottom that doesn't require fault. But assuming that some fault is required, Texas Penal Code has declared there are 4 mens reas, or 4 mental states for crimes. The highest is intentional. Second highest, knowing. Third highest, reckless. And 4th highest, criminal negligence. So almost all serious crimes like felonies will require a mens rea. Only just a very few low-level crimes are strict liability or crimes requiring no blameworthiness. And so we've got to decide, as we look through the Texas Penal Code and as we study different levels of crime, what level of mens rea is required and how does the district attorney prove it in each of these cases. So these 4 levels are very important to know, not just because you'll see them on an exam for this course, but because if you go into law enforcement in any form, you're going to have to know these thoroughly. This concludes Chapter 4A. Now, as I said at the very beginning, Chapter 4 is longer than this, and we've divided Chapter 4 into different pieces so we can have smaller file sizes. So once you complete this, Chapter 4A, you should then study Chapter 4B. Also, all these PowerPoint presentations are not designed to replace reading the textbook. They're designed to supplement reading the textbook. So I strongly encourage you to read the textbook before you go to class. That way, during the lecture of class, this is not the first time that you've seen these concepts, and you're in a better position to ask questions and to understand things. Again, read the textbook and watch the PowerPoint slides, not one or the other. And that's it for Chapter